Hello friends, welcome. Friends, if you recall, 8 days back, I did one video which spoke about why Meta bid copyright lawsuit and what it means for AI authors and you. So these were the stories on the basis of which I have done this video. And I will put a link of this video in the description, and anybody who is interested, they can watch this again. Right? But friend, why I'm doing this video today is because there is another judgment which came recently, which is about Anthropic destroyed millions of books to train AI models report. And then if you look at Indian Express also saying are generative AI models built on stolen creative work, unpacking two courts verdict. AI companies start winning copyright fight, AI copyright disputes. So there have been a lot of articles floating around regarding copyright versus AI, means the copyright owners' protection of their copyright, means to able to license those copyright material versus AI using those copyright material free of cost for training their large language model. Now, India is also working towards training their large language model. And friends, why it is relevant now, more relevant than what it was earlier. It is not just about explaining or talking about a judgment. The whole idea about this presentation or this video is all about that what is going to happen in the future, how the cost of training LLMs, large language model, is going to increase, and what are the practical difficulties which the LLM developers are facing today, and also what are the constraints which the authors who are going and filing cases in the court of law are not able to have the leverage to argue their case properly to able to get a judgment in their favor. So this is a very interesting presentation, friends, because I am going to compare both the judgment, the meta judgment as well as this judgment, which is almost like cascading in nature. So created a slide deck in order to make my thoughts more structured. So the title of this slide deck is AI versus authors, the battle over book licensing. Now, friends, focus on this word book licensing. Why books? There are plenty of material available in the internet, free of cost. It can be picked up from there. Why, LLM or LLM developers are focused on using book licensing? That's the key part of this discussion, and this is so valuable and so important, friends, that it will have a far-reaching implication as we, become more and more gravitated towards large language model, and all countries including India start developing their own LLMs, because without book licensing, without books, the quality of those LLMs cannot be at that level. You can do it by using other methods as well, by doing retuning, refining, and all the things, but books are an essential ingredient and input which makes the LLM much more capable, and it is much cost effective to use a book to train an LLM versus using other methods. So using meta and Anthropic cases to understand the future of LLM training costs. That's the whole purpose of this presentation, friends. Now the context and the legal background, already told you. Two rulings which were castigating in nature. One was the Meta ruling, June 25th, 2025. Another was an earlier ruling, which I did not catch at that particular point of time, which is the Anthropic ruling of June 23, 2025. The central legal question: can LLM developers copy books for training without author's permission? It looks a little strange, right? Somebody writes a book and you copy it, and then you train that book, and then the author goes to the court, and the court says, "Oh, everything is fine. Training of copied books is fine. There is no problem." So don't you find this a little counterintuitive to to digest this judgment that somebody stealing somebody's work, training its a large language model, and it is getting circumventing the court jurisdiction to get a favorable judgment? Very strange, right? So this is what is getting very interesting, and that's why, friends, this copyright and the AI thing, right? This legal tangle which is going on between copyright, it is very nuanced. It's not easy to digest and understand, and very interesting as well, friend. And that's why I, being an engineer, not a lawyer, got gravitated towards this discussion, because this discussion is so important, friends, and very interesting as well. Why books matter for LLMs, which I've already explained. Books provide coherent, high quality, long form data, which is very difficult to get from, going into the internet, because internet is very unstructured. It does not have a long form data with it, which is so coherent and high quality. And therefore, everybody is gunning towards books. Preferred form of preferred over unstructured internet, right? Which is very, very, not properly, laid out. Quality is also very, very bad. But books, somebody puts all its mind to write a book, so it takes he or she takes the pain to structure it properly, so that the thoughts flow coherently rather than in an unstructured manner. Every major model, whether it is OpenAI, Google, Meta, Anthropic, relies heavily on books. And possibly when India also start generating their own LLM, they cannot circumvent books. So this issue is going to emanate in India as well in the near future. How Meta and Anthropic got their books. This is important. And you will find this argument pretty interesting, and it's sometimes hilarious as well, right? It's very, very, if you read the judgment, because I've read both the judgments. If you see here, I have both the judgment here, and I've read, this is a Meta judgment, which was given on 25th of June, I think. And this is the Anthropic judgment. All right. And here also I've gone through each and every word of this judgment. So I find this very interesting. What Meta did, Meta actually torrented books from these sources. And these are pirated sources where, BitTorrent is a protocol which existed long back. I used to use BitTorrent long back. So what it does is it actually captures chunks of books which are, loaded into different website and aggregates them and then downloads those into your computer. These are all pirated books. These are not licensed copy. And while doing so, it uploads also. Means the BitTorrent protocol also redistributes the books. So what happened was, in case of Meta, they did some refining on their software. But the allegation of the authors are that BitTorrent, while Meta used BitTorrent, they redistributed their books. So this is a bigger crime than downloading pirated books and using that for training LLM. It's so hilarious, friends. You can't redistribute, but you can, it is in bad faith. Downloading a book from a pirated website is bad faith, but that bad faith is okay because that's a separate issue. But if you are using that book to train LLMs, and if it is transformative in nature, means it is a completely different product, does not compete with your book in any way and prevent you to monetize your book, it is fine. So that is the kind of situation that is emanating. And I'll tell you, friends, why this is like this and what market aspect, what is the market that is being looked at from the point of view of evaluating harm and which market is excluded. And that is where the problem is, friends. But anyway, we'll come to that as we move forward with the discussion. So in case of Anthropic, what happened? They downloaded pirate books and created a data set, right? They also bought millions of print books. They scanned them and created digital copies. And they claim that when they downloaded pirated data sets, books, they didn't use those. They only, downloaded it for the purpose of research, which one to use, which not to use. But later, they bought all those books in printed form, converted them into digital copies, and then only used those digital copies to train their LLM. This is what Anthropic is claiming, right? So, if you look at this, what they're saying, you download it, just create a data set, looked at the data set to see which one is useful, which one is not, but you keep the data set alive, even if you don't use it for training, but train only using proper purchase books, not licensed books, friends. It is purchased. There's a difference between licensing and purchase. This is interesting. It is getting very, very interesting. And you will understand what are the implications. So summary of the judicial finding is that both judges agreed training LLMs is a transformative use, We also understand, everybody understand, LLM is a product which does not compete with book in direct sense. Means it does not reproduce any of the text of the books. Though it memorizes, it does not reproduce because the fine tuning is done for on the LLM product in such a way that there is no way any kind of prompt that you give, a rogue prompt or an innovative prompt, will not result in the reproduction of the content of the book. And that is why this is transformative use. It does not compete with the original work. So that's the argument. Now, in Meta's summary judgment granted for training use, BitTorrent issue is still unresolved. Means there was an allegation that while Meta used BitTorrent to download the books, it uploaded some books also. And that issue is still unresolved. It is being still debated in the court. Anthropic scanning purchase book is fair use. They're saying that if you are purchasing printed books, you can scan them as long as you are not creating more copies of that scan. You can create one copy, you destroy your printed copy, that is fine. So that's fair use. But piracy archive is not a fair use. Means there is a possibility that an archive that you have created could get somehow misused. Somebody may copy from that archive. Somebody may use that to distribute books to somebody else. Those things have not been finalized yet in the judgment. So fair use upheld that due to lack of proven market harm and transformative in nature. Now this is important. What is the market that they're talking about, friends? And this is where it gets more interesting. See, there are two types of market, which I had already mentioned in my earlier video. One is that direct sale of market of books. Means if I write a book, I can make a sale of the book to the consumer at a particular price. So that is a direct sale market. Another market is licensing market. Now, since the licensing market is not developed yet, that market has been considered as an excluded market. You can't see, the authors were making the point in both cases that the harm that has been caused may not have been on the market, which is the direct market of sale of books. It is on the licensing market, because if somebody copies the book from any pirated website and uses it to train LLM, they are deprived of the opportunity to license. Now, the judges are saying that this is not a developed market and this is not a market which is recognized by the US Copyright Act. But in the Meta's case, there was some more nuanced mention with the judges, the judge made. Judge said that it is possible that the LLM, which has been trained using the author's book, right, which they have copied illegally and trained the LLM, can generate a similar product, right? Which, let's say there is a story which an author has generated, or a book which is a story, some kind of classic story, not a factual book or a story, but somebody generates another book using the LLM, which kind of had learned from the author's book, the original author books, whose book has been used to train. Then that book itself going into the market may undermine the original author's market, which has been used to train that book. Now, this is possible, but this is possible in human sense also. There is a book which has been written, and that book is being read by some school children. They are very intelligent guys. They also grow up, and they grow very soon. They become adult and they start writing books. The original authors market will get undermined because these children who have grown up, they have now become as empowered as the author because they have read the author's book, right? This is the argument. But the problem with the technology is that the technology can scale much faster. The human evolution, right, or the damage to the market is much slower, right? But the technology can do it much faster. Therefore, there could be a direct erosion of the original market which the Copyright Act recognizes. That point has not been, presented by the authors as per the judge, in a very clear and affirmative manner. They're saying that there are no cases, there is no economic analysis. How can it be? There is nothing to prove as of date, maybe tomorrow. So if the authors goes and says that my primary market to sell books are going to get undermined, it is a much more hypothetical argument, because there are no case studies, or there is no even, you can say, anecdotal proofs to give to the judge that this is the reference where this has been shown. It's very difficult to do, right? So because of that, due to lack of proven market harm, this and the transformative nature, this fair use was upheld. Now, market harm and licensing debate, right? Some of it I have already touched. Court rejected author's claim of lost licensing market, which I've said there are two types of market: direct sale market and the licensing market. Court rejected, saying that this is not recognizable by the Copyright Act. Now, my point is that the whole premises of Copyright Act is based on the principle not to demotivate the copyright generator or the author or the art who has generated the art from its ability to monetize. And the monetization can be of any nature. It can be a direct sale, it can be a licensing deal, or anything. You can't really define what kind of monetization that you can do, right? You cannot do that. So the lost licensing market today is a market which has not developed. Because it has not developed, therefore, the court was very right, or they were able to reject the author's claim, because the market has not developed. So it's like a chicken and egg situation, right? So if the market has not developed, court says there is no market and therefore there is no harm, right? So that's the argument. Only traditional sale licensing market is recognized so far. So the implication of this is so huge that tomorrow it will be clearly proven and the market of licensing will be developed. And at that point of time, the court cannot in any way circumvent this author's argument that there was a lost licensing market. And that is going to be resonating with the Copyright Act, friends. And that is what's going to happen in future. This is what we are able to foresee by looking at these cases when I read through this judgment. Licensing for AI training is not seen as a likely to develop as of now, but in tomorrow it will be. Meta court acknowledged hypothetical future harm. Plaintiff offered no proof. How can they prove? Because there is no market yet, right? Why the licensing market may emerge. Now, this is very important because there is growing symptoms that it is emerging because of real world licensing deal, right? News Corp versus and OpenAI. You act. They recognize opt-out and transparency, because you can't use somebody's copyright material to train your LLM if he or she wants to opt out from that model. So that will be a violation. Enterprise clients are demanding indemnified models. Collective licensing scheme are being piloted. So strategic option for LLM developers. Now in this confusion, because look at this situation. You want a license, but the market is not developed. So therefore, the friction of getting a license is very, very high, right? You can't get a license because there is no market. You can't be sending millions of emails to various distributor, authors, everybody. Nobody will respond. Somebody may be sleeping. Somebody may not be using emails. What you're going to do? Tell me. So you have to use books. You cannot stop developing your LLMs. So what you're going to do in a short term? The short term is please don't copy from pirated website. That is the essence of this two judgment. I can understand. Please do not copy. You can go and buy all those books. You have to make the effort. If you are not able to take a license, please go and buy those books. And when you buy those books, can purchase print books with receipt and then convert that into an electronic copy and train. It is much safer because of the Anthropic judgment. It may not be safer, or it may not last for a long time, because once the licensing thing develops, then it will be proven that the licensing market is getting impaired and harmed. And that time you cannot do this. Short term purchase of print books with receipt and training LLMs will no longer work, but it will work in the short term till the time the licensing market is developed. Medium term, blend scan and licensing dataset. Whatever licensing deals you can do it. And rest you can't do. You can just purchase printed book and then go with that. Long term, you have to comply with collective compulsory licensing law. That you cannot circumvent. The way the things are going, that slowly, people will realize that the authors who are writing those books, they can monetize those books using two different markets. So that market is going to develop, you like it or not. And that time you cannot really go about circumventing the market by purchasing books or copying books from illegal website. So implication of the future training cost is going to likely to rise. It's very clear. If you have to go through the licensing deal, you have to pay higher training cost. But it will be much faster and easy to do it. You don't have to go around sending emails and trying to go around talking to people to sign a licensing deal. Global divergence, you versus US legal treatment, that is there currently. EU has got a different law. US has got a different law. They may somehow converge. Today, it is diverged. Unanswered question is fair royalty rates. Means it may be possible that while the licensing market gets developed, there could be another dispute which may sprung up, is about that, these authors are going to charge exorbitant amount of royalty rates. Then how are you going to decide what to do with your models? Will you say that I will not use your books? What kind of legal ramification is going to happen at that particular point of time? There are no legal precedent as regards royalty rates on licensing of books as of now, as to my knowledge. So there has to be some legal cases which will provide some precedents as to how to deal with those situations. Means what is a fair licensing agreement? What is a fair, we call it in case of CDMA, because I'm a technology guy, in case of CDMA or in case of all kinds of 3GPP, Etsy licensing, this consortium where those standards are developed, we call it FRAND, fair non-discriminatory licensing terms. You have to sign a FRAND agreement, right? So similar structure has to be created. And then there are other issues as well. LLM builders can't escape licensing costs forever. It is clear, right, from this. So closing messages, these rulings are just the beginning, not the end. Book licensing markets are forming, fair use will narrow, right? It's clear. Compliance will become more expensive, but also clearer. Authors stand to benefit in the long run through royalties. So thanks, friends, for your time. I hope that you like this video, and thanks for listening till the end. And I'll come back with a new video and a new topic next time. Thank you very much, friends.